Okay, Tiffany Spires versus City of Wichita.
Thank you, Your Honor. May it please the court,
Yeah.
counsel. This is an appeal, as the court knows, of a case arising from a sidewalk in Wichita that had been neglected for 30 years.
You're looking to her because you know she's from Wichita and she's probably ridden that same.
Yes, and because she was on the Court of Appeals during the when the
Zagor, whatever.
yes, when that
Zaragoza.
So this is just you and I now.
They under.
but this is
Were you on Zaragoza? Yeah.
at the Court of Appeals level, yes.
Oh, yeah. I mean, I know.
Interestingly, was it language she used was adopted by the Supreme Court. Quote.
Oh, I know. We know.
This is a sidewalk that goes from downtown to the Linwood South City neighborhoods. And there are a lot of things the court knows that can happen on a sidewalk. People can walk to work, they can do physical therapy, they can have a river festival once a year. And just like the courthouse, and I use this example because I've been at the courthouse when they come in, the carolers come in at Christmas time, a courthouse can be used for caroling at Christmas. It doesn't make it a recreational facility. And while people can do a river festival once a year at a certain part of this sidewalk, this is a city sidewalk between downtown and a neighborhood to the north and between two neighborhoods to the south.
The area the injury took place in was the part of the water walk area though.
There's a hotel there.
Right. I mean,
and there is a park nearby. You can call it loosely a park. It's a large circular space, but it's a city sidewalk. But that's really not, I don't want to concede that this isn't, or I don't want to concede that this is a recreational area, because I really think that the courts over the years have expanded what the statute says.
and they certainly, in Zaragoza, I mean, you have a really hard time trying to get past immunity here in Zaragoza, given the facts of that case. I mean, that was a sidewalk in front of a library.
It was a library. And I was planning to argue about Zaragoza because I don't think it applies at all. In fact,
And why is that?
it wasn't a published decision at the time that the case was in front of the district court.
Well, the Kansas Supreme Court decided it.
Right,
Right. So
right.
we have a published case.
right. It wasn't.
The sidewalk in front of the library is recreational use.
Agreed. We have that. It wasn't published at the time of argument at the district court. And frankly, I wasn't aware of it. It wasn't cited in the brief or wasn't produced beforehand. And it's 41 pages long, which I tried to skim during oral argument. But what I found after reading 41 pages, it has nothing to do with this case. The Zaragoza case dealt with a sidewalk and a curb and a gutter and a drain, just like we see on every block in Kansas and most places around the country where there gets rain. And in every sidewalk with a gutter and a drain, there's a potential for somebody to step in the drain. And in Zaragoza, everybody knew, the city knew, the library knew, everybody knew that there was a sidewalk and a gutter and a drain, just no one thought it was dangerous. That's a very different situation than we have here.
So sidewalks are inherently dangerous.
More dangerous than a walk and a
gutter and a.
That was part of the problem in Zaragoza, because this is an ordinary sidewalk with a gutter and a drain. No one thought this is dangerous. It's normal.
And how is your sidewalk not normal?
You know, in this case, the defense concedes that it was dangerous and that it put people at risk of injury or death. And the reason it was dangerous is because the city created this condition. The city planted cypress trees, of all things, not crimson pygmy barberries. They planted cypress trees in a hole this big immediately adjacent to the sidewalk, knowing that those are fast-growing trees and that this was inevitable. And as you would expect, You plant a big tree like that right next to the sidewalk, literally inches away.
Was there evidence of that, that they did this intentionally and they knew it was inevitable, but
Yes,
gosh be darned, I'm gonna plant it anyway?
there was evidence in the record that these are fast-growing cypress trees. There was not a city commission meeting notice that said, note that said, we're choosing to put in trees that are going to push up the sidewalk. But they did approve cypress.
But you said knew it was inevitable.
These are cypress trees. Botanists have known, the public knows that cypress trees are fast-growing. And you put an oak tree next to a sidewalk, you put a cypress tree next to a sidewalk, it's going to do what we have all seen in.
I haven't looked at the record in this case, but I'm assuming there were cypress trees all up and down this walkway.
There were.
Was this the only place?
Nope. There are other places where the ledge along the water literally had broken off and fallen into the water. It was missing for years, just like this. But, unlike in Zaragoza, the city created this. The city concedes that it was dangerous. In Zaragoza, the city never conceded it was dangerous because it's a gutter and a drain like everywhere else. But the part of Zaragoza that the defendant didn't read, apparently, because they didn't cite the whole sentence, they cited half of a sentence. The part of Zaragoza that actually helps the plaintiff is the part that was adopted by the Supreme Court from the Court of Appeals decision. And it reads, to constitute wantonness, the act must indicate a realization of the imminence of danger and a reckless disregard. That's the half of the sentence that they quote. The rest of the sentence says, quote, or a complete indifference or an unconcern for the probable consequences of the wrongful act. So it's either or. Ignoring for 30 years, a jury could conclude that that is complete indifference or a concern for the probable consequences of their act. Having their own survey done that was in their possession, they produced it to us during discovery, having their own survey done that shows this defect and doing nothing about it. They said, well, we didn't look at it. Well, isn't that something that a jury conclude is complete indifference when they have a survey done that shows this defect, that shows the broken wall that's fallen into the water, and they do nothing about it?
When was the survey?
It was done the year before, 2021. It was done the year of 2022, and it was done the next year, 2023.
But it didn't show the area, didn't show damage to the area.
It did.
Plaintiff was injured.
It did. It is on their own survey, and that's set forth in the expert reports, or expert report, I should say. It's set forth in our statement of additional controverted and uncontroverted facts that they didn't even respond to. And
So how to explain
at the hearing.
how this goes to this seems to be going to gross and wanton negligence.
Absolutely.
But, and you can get past the immunity if you get to gross.
Exactly.
I guess, I think you have a really hard time getting past the immunity, the first step.
Sure.
But what you're talking about is it's gross and wanton because
Absolutely.
they've known all along.
Yeah, I would argue that the courts have wrongly expanded
Nothing we
recreational
can do
use.
about it.
Right, there's nothing we can do about it, but it's gone far beyond what the legislative language says. But if a library is recreational use, then a sidewalk that
In a riverwalk area.
downtown to a neighborhood, then a sidewalk arguably is also a recreational use. I mean, my kids painted on the sidewalk with chalk, so maybe that's recreational use. But
So it seems like that, to me, the crux of your argument is what they did was gross and wanton.
right. There is evidence from which a rational juror could conclude that there's gross and wanton negligence. Their own survey shows this defect, and they don't look at their survey, or if they did, then they had actual knowledge. Either way, we get either the first half of the sentence from Zaragoza, or we get into the second half of the sentence from Zaragoza.
Okay, and so you're saying that there were other places where those trees had cracked the concrete.
Yes,
That's in the record?
it's in the record. It's in the expert report that is attached to the opposition to motion for summary judgment.
Now, is it the concrete of the sidewalk that's cracked, or is it like down the hill, like along the water?
Both. The concrete is cracked, and this is not just a crack.
No,
Yeah, it's not just the crack, but it's also the wall. And that's where the roots from these trees look for water.
right.
And they found water in the river.
But
It's pushed over the wall.
no, I was just,
Yeah.
I wanted to clarify, and I don't mean to talk over you. I'm
No,
sorry.
sorry.
When you said there was other damage, whether there was other damage to the sidewalk or whether the other damage was in reference to the wall, but you're saying that in addition to where they fell, that there was other similar damage.
Yes.
Somewhere.
And this damage, yes, and this damage was so bad, it wasn't just that there was a crack in the sidewalk. The roots had gone through a couple places when they excavated it and found that the roots had pushed up both sides of this slab that's right next to the tree. And then that had caused the middle to crack and the middle to fall. So someone coming along on a scooter with a tiny little wheel first hits something that stops that wheel and then finally gets over it and then goes down when they get to the trough in the middle. But, you know, additional things that the jury could, or a fact finder could find are gross negligence is the city has people who go to this location within 10 feet twice a week to empty the trash can.
But that's a different, I mean,
Yeah, those aren't inspectors.
those aren't, well, right, they're not inspectors, and the people that empty the trash are not likely the people that are in charge of doing some sort of assessment of the integrity of the sidewalk, is my guess.
That may be. They're city employees though. And whether it's a trash worker or a police officer who's a city employee, it's knowledge to the city. The city has conceded that they knew that they had a mandatory duty, and it's set forth in the PIC instructions and Kansas Supreme Court cases. And the city conceded in the depositions that they knew they had a mandatory duty to inspect and maintain, and that they didn't. In fact, they didn't even have an inspection program. Is that my time?
It is.
I talk a lot.
You can finish your thought.
They didn't even have an inspection program. And in depositions, they didn't know which department was supposed to do inspections. A jury may conclude, a rational fact finder could conclude, that if there is this duty and they don't do anything, that's again evidence of gross negligence. They didn't do anything for 30 years for things that are shown on their own surveys, and the defect is shown in satellite imagery as far back as imagery is available, 2017. Thank you.
Johnson.
Thank you.
Thank you, Your Honor. Nathaniel Viertaler Johnson with the city of Wichita. I mean, we agree with the way you phrased the question. We think this is a fairly straightforward application of the recreational use exception, especially after the Zaragoza decision. We understand that it came out during the decision, but I think it should probably still be cited on appeal in the brief and dealt with very directly in that way. That case controls the situation. We think this was a recreational use area. It was an open area for recreational purposes. It's a bike path. That's what their expert says too. Judge is aware of that. I use it with my brother the same way all the time. Riding an e-scooter along it. It's along the river. It connects to a variety of different parks. And under the broad definition of recreational use adopted by the Supreme Court at several times,
And so why wasn't this gross and wanton?
And I think that's the key question. Thank you. It is not gross and wanton negligence because the city did not have specific knowledge of the danger that was posed to the plaintiff in this case. And we think that, and I did read Zaragoza, we cite the whole sentence actually in the brief, and we cite not only that sentence, but the district court judge quoting that whole sentence as well. And Judge Johnson went through each of the pieces of the evidence that were presented here and did not find that it rose to the level of establishing specific knowledge by the city. I think the first thing to address based on the argument by appellant is the survey. I'm not entirely sure what he means by survey. Based on the briefs, it seems to be the survey that we do of all properties for our GIS maps. So we do satellite imagery of the entire area. The city has one, the county has one. They're all over. They establish what properties are what, who's in what district, things like that for the public. That's not an inspection program, and the city does not review every piece of satellite imagery from GIS to determine cracks in the sidewalk. We have a lot of sidewalks. We have a good amount of bike paths and are expanding them as we go all through the city, connecting all around. And the city, unfortunately, does not have the resources to inspect every single piece of pathway.
Yeah, but not having the resources has nothing to do with gross or wanton negligence.
But and fair, Your Honor. I think that it does get to the idea of why it's reasonable for us to establish our program based on complaints from individuals, though.
Okay.
And that's the basis for that. And we think that is a reasonable approach. And the district court, Judge Johnson, found so as well.
So, go ahead. No.
Even in areas that are very much used for this, I mean, you say we have lots of bike paths all over the whole city.
Mhm.
Some of them are clearly not attached to the actual recreation area of this Riverwalk area, right?
True, that is true.
They're through other parts. So we're not talking about far distant ones. We're talking about a place where events are held and
Mhm.
things are done and people change the trash. There's a trash can.
For sure.
So, why not in those areas?
Why isn't there a
How-
heightened duty?
Yeah,
in
how
those
is
areas?
it not?
Oh, I understand, Your Honor. Yeah, it's the same recreational use area. And the city, again, relies on complaints, and in higher use areas, we do receive more complaints. It was described as kind of a huge issue, but as the district court judge found, there's kind of a concave in the concrete, and there's pictures in the record. I've got one here from the petition. It's not kind of the tree roots coming up or anything like that. It's a dip in the concrete. And we hadn't had any employees and he talks about 30 years, we hadn't had any complaints about this issue or the specific danger posed to plaintiff in that entire time.
So
That is what we do our best to respond to.
how do you respond to Mr. Brett's statement that you guys concede that you had a duty to maintain it, but failed to do so? Is that just a general overarching, yes, it's city property, we would obviously have an obligation to maintain it? Or what I get from him is that this was more of a targeted concession. How would you respond to that?
Yeah, I didn't understand it as a targeted concession. We definitely didn't concede anywhere that cypress trees are uniquely dangerous and need to be ripped out from everywhere there along the sidewalks. The city does have a duty to maintain its streets and sidewalks, and that is not questioned here. And I think that comes through maybe in the pattern jury instructions that the appellant cites, where all of those track ordinary negligence, what it is to establish negligence for failing to maintain city streets and sidewalks, but not gross and wanton negligence.
And it may have been ordinary negligence, but it was.
That is true, Your Honor. And that's not something that we necessarily got into, but based on the standard in Zaragoza of having to have specific danger, specific knowledge of the specific danger posed to the plaintiff, we just didn't have that. And there's no evidence of that here.
Is, what do you say to the idea that the people who changed the trash cans should have seen this and are, responsible for seeing this and are city employees, et cetera?
They have a lot of trash cans to pick up, and that's their duty. They're not trained to inspect for sidewalk safety or street maintenance, which seems to potentially be the suggestion. A unique quirk here, too, was the evidence in the record is that the trash can's a little bit obstructed from where this dip in the pathway is. So it's also not something that they necessarily would have seen, even if they were trained on it and still doing their job of collecting trash. And that's just not an obligation that we put on those employees, or we think even maybe if it gets to negligence, doesn't establish that gross and wanton negligence that's necessary to overcome the recreational use exception. And And really, that's really the main part here. And we think a variety of cases kind of demonstrate that. In the brief, appellant talks a lot about how negligence needs to go to the jury, but Zaragoza was summary judgment dismissal prior to going to the jury. So was Lee versus City of Fort Scott and Robinson versus State that are cited by the court. The one that's cited by appellant is Gruen, which is cited in Zaragoza, but distinguished from those facts. And in that case, a golf course property had a hole that someone fell into before. They only put chalk around the hole, someone fell in again. That was specific knowledge. I'll talk to our golf people actually after that one. That was gross and wanton negligence, or at least sufficient to go to a jury. But in all these other cases, not. In Levers, excuse me.
And I don't know, maybe I could just be making things up, but is there like, in the medical practice and negligence, it says what's within the standard, the medical standard of care. Is there a city sidewalk standard of care out there that was discussed? Or,
And maybe I'm answering this incorrect.
Not necessarily what Wichita did,
Mhm.
because maybe Wichita's actions were way outside the norm,
Mhm.
which would go to gross and wanton. So
There's no evidence of the record of other municipalities or governments doing something different than our inspection program.
right.
There's no comparison to what other places, especially a city of the size of Wichita, does to do that kind of thing. There's not another case cited that kind of compares the facts to this one to establish what specific knowledge is. And really, the best we kind of work with are these general negligence standards that are enunciated in the pattern jury instructions of what constitutes implied notice for negligence. How long is something obvious before it's negligence on our part? And that's just a different standard than the gross and wanton negligence necessary for recreational use.
Thank you.
And that's really all I have, Your Honor, if there are any other questions. And thank you so much for having me.
And Mr. Benz, you have 3 minutes for Val. Brett, I'm sorry, Brett, I need glasses on.
Thank you, Your Honor. The defendant's concessions were specific to this area.
Do you have a record site for that? I'm
I
sorry.
do. It's on page 3 of my appeals brief. And it's the testimony of Feist, it's the testimony of Steele and Russell, and then also Degenhardt. And then Degenhardt is the one who said, but the defendant never inspected it ever. The defendant did not even have an inspection program. The law requires them. And the PIC instructions, the comments talk about how this duty is non-delegable. This duty is mandatory, and it doesn't matter if they have the money or not. They have a mandatory legal duty to maintain it in a reasonably safe condition. They concede, and this is the testimony from Feist, Waddle, Steele, and Russell. They concede that it was dangerous, that this condition put people at risk of injury or death. The defendant did not respond. They didn't file a response to our statement of additional uncontroverted and controverted facts. And so under the rules, those things are deemed admitted.
Mhm.
At the hearing, and I know the court has read this, but at the hearing, the defendant conceded wantonness, conceded wanton conduct throughout the hearing.
How did they concede wantonness?
He conceded specifically. So at the beginning of the hearing, the defendant.
Was this wanton conduct? And they said yes?
Yes. At the beginning of the hearing,
Well, that's a legal conclusion though. I mean, they can't see that.
a degree of negligence is a fact question. The definition of wantonness is a legal issue,
Right?
but the degree of negligence, including whether it is wanton conduct, is a factual determination. It is the ultimate determination that a jury would make.
Right, it is.
Yeah.
So you can't he can't testify to the conclusion of the jury.
Interestingly, there's a is it KSA 40-456 that says that an expert may testify in the form of an opinion.
Expert.
Yes, it was our expert, and I'm sorry, I probably can.
Sorry, I was.
Okay, so
that's the
your
city
expert
employee.
said it's
Yes.
wanton.
Okay.
My expert,
Okay.
I'll go through it chronologically. My expert goes through all of this history
Right,
and concludes his ultimate conclusion that this is wanton
sure.
gross negligence.
Okay.
I include that in our statement of additional controverted and uncontroverted facts in my response to their motion for summary judgment. They didn't file a response. So at the beginning of the hearing on the motion for summary judgment, the district judge asked defense counsel, what about each of these additional statements of controverted and uncontroverted fact? What are you concede them? Do you admit them today? Do you deny them today? And defense counsel admitted almost every one. He admitted specifically the one that dealt with recklessness and wanton and gross conduct. Until the very end of the hearing, where the judge said to him, you've admitted gross negligence and wantonness. Don't you agree that I have to deny summary judgment because you've admitted this? He says, okay, well, maybe I need to change that. And at the end of the hearing, he changes. So he's conceded it throughout the hearing. He conceded all the way through until after I was finished being able to argue. And then the judge talks him into changing his concession and saying that this isn't wanton conduct anymore. But the expert, it's in the record already. And under KSA 40-456 subsection D, the expert is allowed to testify on the ultimate issue to be decided by the trier of fact.
I thought you were talking about the city employee.
Oh, yes. No, this is an expert witness.
Okay.
And, you know, since the Kansas Supreme Court says that juries are supposed to decide the degree of negligence.
And that's your bottom line.
Yeah.
Shouldn't have been summary judgment. It should go to the jury to make.
Exactly. I don't need to argue anymore. Thank you, Ron. Thank you.
Both very much. An opinion out as soon as possible.